On March 19, 2026, in a Michigan district court, defendant Lorenzo Harris appeared before the judge for a subsequent hearing in a landlord-tenant dispute with plaintiff Tailwind Bloomington. The case, number 2501, involved non-payment of rent and had previously resulted in a possession judgment against Harris. What unfolds demonstrates how consent agreements can resolve eviction proceedings and the critical legal safeguards protecting unrepresented tenants in these high-stakes negotiations.
Be right with you.
Good morning. We are on the record in the matter of Tailwind Bloomington versus Lorenzo Harris. This is case 2501T. May I have appearances for the record? And Mr. Harris, if you could unmute and turn your camera on, please. There we go. And appearances, Mr. Nerat.
Yes, Your Honor, to please the court, Attorney Frank Nerat for the plaintiff landlord, and I'm filling in for the Whitty Law offices this morning on this case file.
Thank you. Mr. Harris, could you please state your name for the record?
Lorenzo Harris.
All right, thank you, sir. And this is a subsequent hearing in a landlord-tenant matter for non-payment of rent. So first, I'm going to ask Mr. Nerat, because he represents to convince the court something happened. Then, Mr. Harris, I'll ask you. So first, Mr. Nerat, what do you have for the court this morning?
Thank you, Your Honor. We had a nice, good meeting in the breakout room. My client has agreed to reduce from what they were claiming was owed by about $450. So what we've agreed to is entry of a consent order for possession judgment, that the plaintiff has a right to recover possession of the property. There's now due to the plaintiff for non-payment of rent an agreed upon reduced amount of $1,500. We have court costs of $161.32 for a total possession judgment of $1,661.32. The parties have agreed that plaintiff can apply for an order of eviction if either the defendant does not pay that amount or does not move on or before March 19th of 2020. The defendant may be liable for money damages after moving if additional rent owed or if there's damage to the property. Acceptance of a part payment will not prevent the court from issuing an order of eviction, and no money judgment is entered at this time. We also would provide for a motion for a new trial or appeal, and that have to be filed in the court by that March 19th of 2026. We've discussed this, we've agreed to it, and Mr. Harris has given me permission to sign his name to a consent order for presentation to the court, assuming that it's
So, Mr. Harris, first, is that all accurate?
Yes, ma'am.
The landlord's attorney presented a negotiated settlement, reducing the claimed debt by $450, seeking a consent judgment for possession that would allow eviction if Harris fails to pay $1,661.32 or vacate by a specified date. Under Michigan Court Rule 4.201, landlords must obtain a judgment of possession before executing an eviction, and consent judgments are permitted when parties voluntarily agree to resolution terms. The rule requires that any possession judgment include the specific amount due and provide clear notice of the tenant's obligations to avoid forfeiture. Additionally, Michigan Compiled Laws Section 600.5744 governs the issuance of writs of restitution, requiring 10 days between judgment and eviction unless the court orders otherwise, a protection the judge here explicitly treats as a minimum floor rather than maximum ceiling. The parties utilized the court's breakout room procedure under MCR 2.410 to negotiate privately before presenting their agreement. The landlord's attorney properly structured the consent judgment to include the reduced rent amount, court costs, and a clear pay or vacate deadline, satisfying the statutory requirements for a valid possession judgment. The judge's intervention to extend the deadline from March 19th to March 23rd demonstrates judicial discretion to provide additional time beyond the statutory minimum when fairness warrants. Consent judgments offer tenants a critical opportunity to avoid immediate eviction by negotiating manageable payment terms, but they also carry significant risk. Failure to comply precisely results in automatic eviction rights for the landlord. The 10-day rule exists to prevent precipitous displacement, and judges who interpret it flexibly, as this judge did, can mean the difference between a tenant retaining housing and becoming homeless over a minor timing discrepancy.
I just had one a question, if it could be done.
Yes, please.
I just checked the calendar on the 19th, and I don't get paid till the 23rd. Is it possible if we can move switch it to the 19th to the 23rd.
Well, the court rules say 10 days. I tend to interpret that as a floor and not a ceiling, but whether he wants to go further than that would be up to Mr. Nerat. So Mr. Nerat, your response?
I can just promise you that it will be there
No,
on
just a
the.
minute, Mr. Harris. I'm going to let Mr. Nerat respond, then I'll come back to you, okay? Thank you.
I'm willing to modify what we had agreed to the 23rd, Your Honor. That would be a 23rd to pay or move by the March 23rd instead of the 19th.
Okay, thank you. Mr. Harris, does that work for you?
That's absolutely amazing.
So is what Mr. Nerat said, other than the date, all accurate?
No, that was all accurate.
Okay. Do you have anything to add to it other than the date, which we just handled?
No, I will pay her $1,000 today or between that, and I'll give her the rest on the 23rd.
Okay. What questions do you have?
No, I appreciate Mr. Nero.
Okay, actually, can I bring your camera back? Thank you.
Harris successfully negotiated a 4-day extension to align the payment deadline with his payday, and the judge confirmed the modified agreement's accuracy while ensuring Harris understood his obligations. The Michigan Summary Proceedings Act, MCL 600.5701 et seq., establishes that tenants have the right to cure non-payment by tendering full rent plus costs within the statutory period, but parties may contractually modify these terms through consent agreements. Under MCR 2.507, consent judgments have the same force and effect as judgments entered after contested hearings, meaning breach triggers the same enforcement mechanisms, including immediate eviction without further proceedings. The rule requires that courts ensure consent is knowing and voluntary, particularly when one party appears without counsel. Harris's request for a payday-aligned deadline illustrates a common tenant predicament. Court-imposed timelines often ignore income cycles that determine actual ability to pay. The judge's willingness to facilitate this accommodation, treating the 10-day rule as a protective minimum rather than rigid maximum, demonstrates proper exercise of equitable discretion. However, Harris's partial payment plan, $1,000 immediately, remainder later, creates enforcement risk, as MCR 4201K permits landlords to proceed with eviction upon any default, regardless of good faith partial performance. Judicial flexibility in eviction proceedings can prevent homelessness, but tenants must understand that consent judgments are binding contracts with severe breach consequences. The one thin dime rule the judge references reflects harsh reality. Landlords need not accept partial payment once judgment enters, and courts will enforce literal compliance. This asymmetry tenants must perform perfectly while landlords retain discretion makes comprehension of consent terms absolutely critical for unrepresented parties.
All right, so you're going to pay or vacate on or before
Yes, ma'am.
March 23rd, 2026. You're going to pay a total of $1,661.32. Now, here's the thing. If you are even one thin dime short under the court rules, a landlord can go ahead with evictions. But I'll also tell you this. Most landlords don't like coming to court any more than most tenants do. So please stay in touch with.
Yes, ma'am.
All right. Now, does Mr. Nerat have permission to sign your name to this agreement?
Yes, ma'am. I already gave him permission.
Okay. And you can tell Mr. Nerat's an attorney because he wears very nice suits. So because he's an attorney and because you're not represented by an attorney, you have 3 days to reconsider this decision. So if you think you've been misled or didn't fully understand it, the very first thing you do is contact the Whitty Law Firm. And the very second thing you do is.
I got one more question before,
Sure.
like, okay, so, if I wasn't to pay it all, which just hypothetically speaking, when I move out, I will not have to pay like the rest of the term on my lease because of what I signed on my lease already, or it'll be all okay.
I'm going to let Mr. Nerat answer that.
The judge issued a stark warning about strict compliance, confirmed Harris's consent to have the attorney sign on his behalf, invoked the 3-day reconsideration period for unrepresented parties, and Harris then asked a critical question about future lease liability. Michigan Court Rule 2.507D requires that courts advise unrepresented parties appearing against counsel that they have 3 days to rescind consent judgments, a safeguard implemented after studies showed high rates of uninformed waiver among pro se litigants. Under MCL 600.2918, landlords may pursue separate actions for damages, including unpaid future rent after eviction, though such claims require new filings and cannot be appended to possession judgments. The distinction between possession judgments, eviction authorization, and money judgments, debt enforcement, is fundamental. MCR 4.201 permits bifurcated relief where landlords seek only possession, reserving monetary claims for subsequent litigation. The judge properly triggered the 3-day reconsideration warning required by MCR 2.507D, recognizing the power imbalance between represented landlord and pro se tenant. Harris's question reveals critical confusion about lease termination consequences, specifically whether eviction extinguishes remaining lease obligations. Attorney Nerat's subsequent clarification that no money judgment was entered, but that future damages claims remain possible, accurately reflects Michigan's bifurcated approach. This proceeding resolves possession only, while economic disputes survive for separate adjudication. The 3-day reconsideration period represents a vital, underutilized protection. Many tenants sign consent judgments under pressure, without understanding that they retain a brief window to seek counsel or renegotiate. Harris's question about lease liability exposes a common misconception that eviction ends all financial obligations, when in reality, landlords frequently pursue former tenants for unpaid rent, damages, and accelerated lease payments. Understanding this distinction helps tenants make informed decisions about whether to fight possession or negotiate exit terms that limit future exposure.
There is no request for a money judgment in this case. So this is either if you want to stay, you have to pay the amount that we've agreed to today. If you decide to move out, if there's additional rent owed or if you've done damage to the property, the landlord would have the ability to come back to court and file a new case against you. But that's not part of this case, and we're not claiming any that you would have a judgment against you where we could garnish wages or do those sorts of things. That's not part of this case, but theoretically or possibly if you trash the place before you moved out.
Oh, absolutely not.
Okay, but just if that happened.
If
Okay.
that were to happen, or if you delayed moving out and there was additional rent owed, they could file a brand new case against you for those damages, but that is not part of this case.
Yes, sir.
So any additional questions, Mr. Harris?
No, ma'am, that was the last one.
Okay, excellent. Anything further, Mr. Nerat?
Nothing further for the plaintiff, Your Honor. Thank you very much.
Thank you. Anything further, Mr. Harris?
No, ma'am, that's all.
Okay, well, Mr. Harris, I hope you take this in the spirit with which I intend it. I hope you never see me again in your life.
I hope I don't either.
Okay, now feel just a little smidgen of pity in your heart for Mr. Nerat because he has to come back every so often, okay?
No, I
So-
love that. That's a nice guy right there. I appreciate you, Mr. Nero.
Okay.
Have a
All
nice
right,
day.
thank you both, Mr. Nerat. You'll submit to the court, and that is all for this record. So, Mr. Harris, you can disconnect. Mr. Nerat, I think you're with me for one more.
Correct. Thank you, Your Honor.
Thank you. That is all for this record.
And would the parties like a breakout room for this matter, which is with Mr. Sweet? Mr. Sweet, would you like a breakout room to talk to Attorney Narrett? You are muted.
Sorry about that. I didn't.
It's okay. Would you like a breakout room?
Oh, what do you mean by that?
You'd go into the breakout room and speak with the attorney regarding your matter prior to speaking with the judge.
Yeah.
Okay, give me 1 second. Thank you, and the judge.
The court accepted the parties' modified consent agreement, granting Tailwind Bloomington a possession judgment for $1,661.32 with a March 23, 2026 pay or vacate deadline. Lorenzo Harris retained his 3-day reconsideration period as an unrepresented party, and no money judgment was entered, preserving the landlord's right to pursue future damages through separate litigation while limiting immediate enforcement to possession only. This hearing illustrates the delicate equilibrium Michigan law strikes between efficient landlord remedies and tenant protections in eviction proceedings. The consent judgment mechanism under MCR 2507 and MCR 4201 offers a pragmatic alternative to contested litigation, but its effectiveness depends on genuine comprehension, hence the mandatory 3-day reconsideration period for unrepresented parties, a procedural safeguard reflecting courts' ethical obligations to protect vulnerable litigants. The bifurcation of possession and monetary claims, rooted in MCL 600.5744 and MCR 421, serves dual purposes. It streamlines eviction proceedings while preserving tenants' rights to contest damages calculations separately. Yet this structure also creates strategic complexity. Tenants like Harris must understand that agreeing to possession judgments may invite future litigation, and that partial payments, while demonstrating good faith, provide no legal protection against strict enforcement. Most significantly, the judge's interpretive flexibility, treating statutory minimums as protective floors rather than rigid ceilings, demonstrates how judicial discretion can humanize legal formalism. The 10-day rule in MCL 600.5744 exists to prevent precipitous displacement. Judges who wield it generously, as here, honor its protective purpose while respecting the efficiency interests underlying summary proceedings. For tenants navigating eviction's intersection of contract, property, and procedural law, such judicial engagement can mean the difference between housing stability and homelessness. If you or someone you know faces eviction proceedings, remember, you have rights, including time to seek legal assistance, and, if unrepresented, a 3-day window to reconsider any consent agreement. Contact your local legal aid society or tenant rights organization immediately upon receiving eviction notices. Early intervention preserves options that disappear once judgments enter.